purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi to Indian National Congress or Bharatiya Janata Party, because their office is situated here, they can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. Now, 4, separate storage and separate collection of data ensures that there are no direct linkages maintained in the database between the donor details with donee details. 5, the register which is maintained at the designated branch, please mark this, which issues the bond does not maintain the register with names of the purchaser or the donor. So if I go and buy a bond worth 1 crore, the register would only say one bond issued, 1 crore rupees. My name will not come. The only person, my lord, I must, my lord, tell your lordships, which would temporarily come to know would be the cashier, my lord, when I go with my KYC documents. Because
the issuing bank.
Yes, the one person.
11.1 says all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes, so it will have to be through banking channel. No, the purpose is
the issuing bank, and therefore the issuing bank has all the data.
No, it would come. Therefore, it would come. The only person who would first know my name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. So it comes. The details of donor, i.e. the KYC details, are put in a sealed at the end of each tranche, because within 15 days, many people purchases many multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. Tranches by the designated branch and sent in a sealed covered form to the SBI main branch, Mumbai main branch, where it remains sealed till the contingency under clause 7.4 arises. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So far as the redemption of these bonds by the political parties is concerned, each party can deposit such bond only in their designated account. In account details of the political party also, only the amount of the bond will be reflected, as the bond does not contain the name of either purchaser, donor, or the political party. The political parties would have one designated account in one branch out of the designated branches of SBI, in which only the redemption of electoral bond is permissible. So bond may have been purchased, my lord, from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. At the time of redemption, the original bond, the pay-in slip would be storage in a sealed cover and sent to SBI Mumbai main branch. Both the sealed covers cannot be opened either together or at different times, except under the contingency under clause 7.4 arises. In the event of contingency under clause 7.4 arising, it would be very difficult to trace out that. Even after that, my lord, kindly see this. It's not as if we open the cover and match it. Trace out the details of the purchaser of the bond, as such purchaser may have purchased several bonds from several designated branches in different tranches. In other words, several sealed covers may have to be opened and examined. 2. So far as details of redemption details are concerned, they are stored in the Global Information Technology Center of SBI, which stores the data in a digital format. In case the link between the donee and the donor is required to be established in terms of clause 7.4, it would require a detailed and in-depth tracing out of information from two different information silos of donors and donees. The said exercise is not automated and cannot be carried out in a linear fashion and requires a scanning of different databases which are designed without maintaining interlinkages. Therefore, the process of issuance and redemption of electoral bond and data generated therewith is not maintained in a central database, and the data sheets are not populated and tallied at one end. There exist no direct linkages, and completely separate information silos are stored under separate heads with separate departments. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was, Lord, explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers. It goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say that please criminalize if there is anybody who breaches this system.
Yes.
Yes. Now, Lord, I'll come to, my lord. Please come to page 36 of my written submissions. Rather, my lord, I would, my lord, at page 37, my lord, I have quoted Puttuswamy. And my lord, I'll abide by the time, my lord, your lordships have indicated. But your lordships would, my lord, bear with me. I have never, I have not repeated, my lord, except.
No, not at all.
Lord, I'm not reading this Puttuswamy, my lord. Your lordships, all of my lords have read and read it. But the purpose, I'll say, Lord, your lordships have devised this concept of informational privacy. Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied that system is in public interest, your lordships can, Lord, accept my right to informational privacy as against general right to know. And why, my lord, I say this? If there is a genuine public interest in the disclosure, you go to the court, you have 7 for remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. Lord, that's the Lord, submission which I have made, my lord. I have quoted the relevant paragraph. I'm not, my lord, reading it. Your lordships are aware. Lord, please come to. You are saying that you are into. Come to page, I'm sorry,
Yes.
page 39. I'm just skipping through, my lord, rest.
Yes.
My lord, not that I'm giving up, my lord, maybe treated as read.
Yes.
Para 95. In the matter of Puttaswamy, this honorable Justice, it should be Justice Puttaswamy, this honorable court discussed the validity of section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. Lord, I was on 95 reading Puttaswamy, second para, 95 second para. It is submitted that while upholding section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court. So it's not, my lord, as if it's an afterthought which I'm suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Then your lordships, my lord, kindly skip the rest and, my lord, come to, my lord, I have quoted, my lord, FAQs which are relevant, my lord, but broadly I have indicated, my lord, what are those, my lord, FAQs. Please come to, my lord, page 46, lord, 46. But this I have already argued. I will not, my lord, bother your lordships. Please come to page 48. Lord, here, my lord, I would respectfully seek permission to read only few paragraphs of the judgments, my lord, because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. Lord,
Yes.
nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused.
You are reading the Shirur Mat case?
Yes, my lord. Lakshmindra Tirth, my lord, the Shirur Mat, my lord. Kindly see the last three lines which are bold and highlighted, my lord. For your lordship's convenience, my lord, I have done this. I don't wish to read the whole. The saving provision contained in section 91 of the Act makes the position quite clear. An apprehension that powers conferred by this section may be abused in individual cases does not make the provision itself bad or invalid in law. But this is, your lordships are aware, my lord, seven judges case. 7 judges judgment. It can, my lord, in Indian ingenuity is, my lord, popular around the globe. And general human ingenuity, my lord, everywhere this is happening. Then, my lord, please see 117. Similarly, in collector of customs versus so-and-so, this court observed the possibility of abuse of a statute otherwise valid does not import to it an event of invalidity. Further, in state of Rajasthan, it was said that it must be remembered. You know, these are very well put, therefore I am tempted to read. It must be remembered that merely because power may sometimes be abused, it is no ground for denying the exercise of power. The wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. So there can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Then, my lord, Keshavanand Bharti, in exercising the power of judicial review, the courts cannot be oblivious of practical needs of the government. The door has to be left open for trial and error. Constitutional law, like other mortal contrivances, has to take some chances. Opportunity must be allowed for vindicating reasonable belief by experience. Look, the government, which consists of all politicians, the parliament consisting of all people in politics, Lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. Lord, that trial and error, my lord, the government is entitled to. My lord, then, my lord, I am not reading Mafatlal, but please, my lord, come to, my lord, I am not reading A.K. Roy also, please treat it as read. Please come to PUCL. Lord, PUCL also, my lord, is on the same lines, my lord, therefore there is no point in duplicating. My lord. Then, my lord, I have pointed out right, my lord, legitimate state interest. Lord, your lordships would always balance. I have argued this, my lord, I will not take your lordship's time further. But the legitimate state interest is linked to public interest. So you have the right to information, no denial, but you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash economy to enhance, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my lord. Lord, please see para 130. It is submitted that specific judgment in PUCL and SO, my lord, which were referred to by them, sought disclosure of information which was already in the knowledge and possession of the state authorities. When they say that you declare what is your property, you declare what are the criminal proceedings, these are all in public domain. At once platform you declare, but here you are trying to lift the veil of confidentiality, which is by design made a part of the very system and which is the pivotal part of that system. And even the government doesn't know it. So, right to information cannot be claimed from me. Now, your lordships may, my lord, kindly go to Lord Lord, page 60, Lord, one passage from Puttaswamy. This is the majority view, my lord. Of course, my lord, all views are concurring except on the ground of, except the question of money bill. Privacy, your lordship gets that? Privacy and proportionality are two interlocking themes that recur consistently in the above judgments. Privacy, also construed as informational self-determination, is a fundamental value. There is a consistent emphasis on the impact on personal dignity if private information is widely available and individuals are not able to decide upon its disclosure and use. This right of controlling the extent of the availability and use of one personal data is seen as a building block of data protection, especially in an environment where the state of technology facilitates ease of collection, analysis, and dissemination of information. Then your lordships may, my lord, kindly see how, my lord, the judgments cited are different. My lord, I have already said.
Yes.
My lord, level playing field, my lord, I have dealt with at page 64. But, my lord, I have already, my lord, orally made submissions before your lordships, my lord. But kindly see, my lord, 151, para 151 at page 65. I have already marked, my lord, which portion I'll skip and which portion I think I must assist your lordship with. 151. The petitioner claims that there is an incumbent bias as a large amount of money go to the ruling party. It is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And, my lord, I have already said that that has been the trend. The ruling party gets maximum because the ruling party has the confidence of the maximum people. Yes. Now, my lord, page 65 bottom. My lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. In the uneven level playing field, you've referred to fairness of elections. That issue is not been addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money power, has that been addressed here? Because that may be a larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point out.
No, you've argued that because of ruling party has always been getting substantially more donations.
Lord, average Indian voter, be it corporate or an illiterate voter, my lord, we have to accept this fact. And we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum my lord, political contribution, because the voter knows that in 2014, the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission. The, my lord,
according to even otherwise, the ruling party would get.
Always. Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme, the ruling party is getting any benefit and there is no level playing field.
Yes.
Lord, I have analyzed, my lord, in secret ballot, that secrecy per se is not antithetical to free and fair elections. Sometimes it enhances free and fair elections. Like, my lord, in my respectful submission, the present case. Lord, kindly come to, my lord, page 70, para 165. Lord, where I have, my lord, attempted to address how, my lord, this scheme accelerates or enhances free and fair election, my lord. It is submitted that your lordships have, my lord, para 165, my lord Justice Padiwala.
Yes.
It is submitted that a conjoint reading of the principles of secret ballot and the right to privacy under Article 21 clearly postulates that there exists a claim on part of the donors to make donations without fear of reprisal. It is submitted that such right would obviously not be absolute and would have to be counterbalanced with public interest and concept of free and fair elections, and further optimized with policy interest of bringing the first step of shift from cash to banking channel in political donations. It is submitted that the balancing element in the present policy is clause 7.4 of the electoral bond scheme clearly provides for disclosure in case of appropriate proceedings before the competent court or criminal proceedings. Lord, then I'll not, Lord, bother your lordships further. Lord, then kindly come to page 73. Lord, financial policy and limits of judicial review. Lord, I am not going to read the whole. I'll just read the highlighted part because that would, my Lord, in the facts of the case, be very, very relevant and direct for assisting your lordships. Lord, first is Rustam Kawasji Cooper. Your lordships, Lord, know the judgment. Lord, it's a bank nationalization case.
Then Garg is the bearer bonds.
Yes, my Lord, 63. My Lord, would your lordships like me to skip, my Lord, to Kawasji Cooper, my Lord?
Absolutely. You can just show us the title of the
Yes.
case and then we'll
Yes.
read it now.
Then my
all
Lord,
old,
in
well
RK
studied
Garg,
history.
I would like to read, my Lord, few paragraphs which are not quoted. Kindly go to, my Lord, page 2175. I'm sorry, my Lord, there is a mistake in volume 2, 2184, my Lord. Allow me to read, my Lord, only few paragraphs.
Same volume.
Volume 2, my Lord, main volume. 2184. Yeah.
Yes.
Lord, please read
So
para
which
16 and 17, my Lord, at page 2194, my Lord. Para 16. My Lord, here also it was concerned with the black money part. Therefore, my Lord, I am tempted to read 16. Your Lordship gets, my Lord, page 1924, my Lord. 2194, sorry. 2194. It was then urged, your Lordship gets, my Lord.
Yes.
It was then urged on behalf of the petitioners that section 4, clause C operates only in relation to a period.
That is,
I'm sorry, para 16.
That's 2203.
203.
2203.
I'm sorry. Your Lordship,
2203.
I'm giving wrong pagination because there are two paginations. 2203.
It's the PDF.
My apologies, I stand corrected. I'm obliged to my Lord Justice Party. It was then urged on behalf of the petitioners that my Lord Justice Gawai got that section 4, clause C operates only in relation to a period before the date of maturity of special bearer bonds, and after the date of maturity, the holder of special bearer bonds can sell such bonds and without running any risk disclose the consideration received by him as his white money, because section 4, clause C being out of the way, he can account for the possession of such money by showing that he has received it as a consideration for sale of special bearer bonds. And so far as the purchaser is concerned, if he has paid the consideration out of his black money, he can claim the immunity granted under clause 3. Thus, the black money of the seller, which had been converted into white on his subscribing to or otherwise acquiring special bearer bonds, would remain white, and in addition, the black money of the purchaser would also be converted into white by reason of his purchase of special bearer bonds. This argument, plausible though it may seem, is in our opinion fallacious and cannot be sustained. It is highly debatable issue whether, under the provisions of the Act, special bearer bonds are at all intended to be transferable after the date of maturity. Here, my lord, 15 days. Here, their maturity was long period. For the postulate of the legislation clearly seems to be that on the date of maturity, the special bearer bond will be encashed. It is indeed difficult to believe that anyone holding special bearer bonds would keep them uncashed without earning any interest from and after the date of maturity, when they can be immediately encashed and the amount received can be invested yielding interest ranging between 18% to 40%. Moreover, special bearer bonds would cease to be exempt from wealth tax from and after the date of maturity, and they would therefore be includable in the net wealth. My lord, last line of this paragraph, my lord. But the law cannot be condemned as invalid on the ground that after a period of 10 years, it may lend itself to some possible abuse. Lord, please come to para 19. Lord, the argument that black money would be promoted is dealt with, my lord. Lord, please read, my lord, para 19, my lord. It's a long para. I don't propose, my lord, your lordship's time. But it's a similar argument that you are encouraging black economy. The court, my lord, analyzed the entire scheme and said that no, it brings the clean money into the system. Now, my lord, coming back to my written submissions, my lord. Lord, please come to para 78. My lords are aware, but I am always tempted, my lord, to show these judgments, my lord. The Lochner era, my lord, which is known as Lochner era, where the Honorable American Supreme Court was having 7 honorable judges, and whenever there was a economic policy change by then the president, it used to be struck down with the majority of 4 versus 1. And popularly, the 4 were known as 4 horsemen, and less known fact is 3 were known as 3 musketeers. That in America this is possible, but be that as it may. No, I'm sorry, 9, but one was being convinced by Justice McReynolds. It is believed that he used to convince. But let's not go into it. Lord, this is Lochner versus New York, ultimately overruled. But Lord, your lordships would recall, Lochner versus overruled starts with a dissent by Lord Justice Brandis.
Justice Holmes as well.
First by Holmes, thereafter Justice Brandis, and thereafter that popular article written by Justice Brandis on privacy in Harvard Law Review, and eventually, my lord, this was the Lochner was, my lord, declared, my lord, not to be a good law, my lord. That also I have, my lord.
All right, we can skip.
But, my lord, it says the government or the legislature, not the government, the legislature has a right of trial and error. No, this is accepted by our court recently, my lord, reasonably recently, when IBC was challenged. But there were several issues in IBC. There were several lacunas pointed out in IBC. But the court said that free play in the joints will have to be given. Even trial and error, unless it is so abhorrently or atrociously arbitrary that it can never satisfy our conscience, the court would defer to the wisdom of the legislative action.
Even in demonetization, we are also.
I have relied upon that, my lords. Please see, my lord, at, where is the judgment? I've just, my lord, we have quoted that judgment, my lord, your lordship's judgment in demonetization. But I'll just, my lord, give that site, well, but the pagination. Lord, I have not marked, but I'm relying upon the,
Vivek Narayan Sharma.
pardon, my lord?
Vivek Narayan Sharma.
Vivek Narayan Sharma, my lord. Lord, page 76, my lord, I'm sorry, page 76, my lord. My lord, it is page 76, my lord. Vivek Narayan Sharma versus Union of India. The lordship would find it at, it's 2023 SCC online, page 1, where my lord also accepted, my lord, this proposition that government can have trial and error unless it is ill-intended, so atrociously arbitrary that it shakes your lordship's conscience, or it doesn't achieve the object it seeks to be achieved, or it is for a different object. But suppose the object would have been that the government of the day, the ruling party, would like to know who paid what to whom. Lord, I have therefore, my lord, satisfied your lordships that please criminalize if there is any breach of confidentiality.
Anything else now, Mr.
My lord, your lords, my lord, one of the questions, my lord, only 5 minutes, my lord, was what happened after the scheme was introduced. What is the trend, my lord? My lord, that we have given, my lord, in document number 2A, which, my lord, we highlighted yesterday.
Full compilation of documents.
Six is pre-demand situation. इसमें देखेंगे voluntary
My lord, these are figures, and my learned colleague, my lord, has examined these figures. If your lordships can give him 5 minutes to explain what is post-scheme situation, my lords.
Okay.
My lord, that he would be able to do it better, my lord. I'm never good at figures, and my lord.
Volume 2A, no?
Please, my lords, it is the compilation that is on the screen right now.
Yes.
If my lords would come to PDF page 8 of that compilation, it would show the party-wise income from unknown sources. This is a report by the ADR itself for financial year 17-18. So this is the pre-electoral bond scenario. In the first table, on the left-hand side column is the name of the political parties. The second column
What page is that?
is page number 6 at the top, but I believe the PDF page would be page 8.
It's page 6 only.
At the top right-hand side, the page numbering is page number 6.
Volume 2A, right? Compilation documents?
Yes,
Please, ma'am.
page 8.
Yes.
Please, my lords. So Annexure 1, party-wise income from unknown sources, financial year 17-18. The first table has on the left-hand side column the name of the political parties. The second column, now this is the pre-electoral bond scenario because 17-18. Second column has the voluntary contributions below 20,000. I believe the Solicitor General has already explained that how this below 20,000 rupees mechanism was previously a sort of a loophole where contributions could come in without there being any identification. So this shows that how the first party has received about 342 crores in this financial year.
Yeah.
The third political party has received about 36 crores in this financial year, and the numbers go on. In the Second annexure, my lords, if my lords sees the third political party, the total income from unknown sources is 39 crores. That contributes to about 37% of the total income. Now, my lords will see a trend which starts from 2018 onwards, that these contributions below 20,000, which if, for the lack of a better word, I can term as sort of slightly dubious contributions, have gone down. And simultaneously, the contributions by the electoral bonds have gone up.
2018, there was an amendment.
Please, my lord,
Because-
2018, the bonds coming.
1 minute, please. Bonds is one thing, but the cash amount which would be deposited had come down to 2,000 rupees.
My lords,
Is
I
that
believe
correct?
No, my lords, the 29C amendment keeps it still at 20,000.
29C amendment, but cash deposits were restricted to 2,000 rupees. Is it correct?
No, Manoj, the declaration requirement is in 29C itself, so that amount remains 20,000.
If it is
So still till date, less than 20,000 rupees can be deposited without it.
Till 20,000, above 2,000, you had to declare your identity?
Above 20,000.
Oh, that was retained, but
That-
cash deposit were restricted to 2,000 after the amendment in 2017. When was the amendment with regard to 2,000 rupees?
No, Manoj, there is no specific amendment with regard to 2,000 rupees.
There is no specific
No,
amendment.
The amendment on 2000 is in section 13A of the Income Tax
Income
Act.
Tax
What it does is that up to above 2000, if you pay by non-cash means, then you won't get the exemption under 13A of the Income Tax
It has
Act.
nothing to
But
do
the
with the
disclosure for 29C remains 20,000. That's right.
That 29C
Remains as it is to that extent. Manoj, the next year, that is
no, but
2018
that
and
may be reflected because of the amendment in the Income Tax Act.
Manoj, they may not want to take the exemption also.
No, nobody. I'm yet to see a political party which will say, so once the restriction under the Income Tax Act 13A is made 2,000, the immediate impact thereof is that the figures which will be disclosed will, below 20,000 will come down.
As at the same time, my lords, because there is another mechanism of electoral bonds, that figure has gone up.
Then show us how many deposits were made through electoral bonds of less than 20,000.
My lords, may come to page number 13. There is something.
If that is so, then it will be reflected in deposits of less than 20,000.
There is something else also that comes out from it. The political party that has taken a principled stand of not accepting electoral bonds is still accepting those less than 20,000 rupees voluntary contributions. My lord, may come to page number 13,
That
which is
we
the
saw,
physical
that the
page number.
CPM is
Please, Milas.
accepting. Yes.
Page number 13, it may be page number 15 in the PDF.
Do we have the breakup of the bonds less than 20,000 and above 20,000? No.
My lords, I don't think so.
Because
That
all
breakup.
are, 1000 is the smallest denomination.
I'm aware of.
Because all of them are without any disclosure
Any
requirement. So that works across the bar for the electoral bonds.
Anything else?
My lords, this is the point. If my lords wishes, I can take my lords through
No,
the
we've seen
number.
that, page 13.
The numbers of electoral bonds will increase. The numbers of voluntary contributions less than 20,000, which are the dubious transactions, will decrease. The only political party for which it has not decreased is the political party that has taken the stand that it will not take the electoral bonds. So obviously that is a political party that is continuing in the older regime.
What is the ratio of the increase in non-bond deposits?
Well, as the
Cash.
non-bond deposits have
Or
gone
through-
down.
No, non-bond deposits. If we exclude the bank transactions, what is the ratio in that?
Well, as the bank transactions have remained the same. If my lords comes to page number 13, and if I would show the latest
Non-electoral, not bank transaction.
non-electoral bond plan.
So you can pay by check also.
Correct.
My lords may see the latest numbers at page number 40. It would show that the first party has received about, page number 40 would be 40.
This is the ADR report.
One chart and give it. What we can do is, by tomorrow, not for arguments, we can compile this, we understand.
I have got note of 2 pages or so.
Not a note.
Just a
and
compilation.
chart.
Correct.
A
A
chart.
chart actually, a tabulation you can give us.
Yes, that
All
will
right.
be.
Thank you. Where is Mr. Amit Sharma?
He's maintaining his confidentiality. It's on the lighter side.
Well, we can start with the learned attorney, then we can hear Mr. Amit Sharma at the end.
Yes. Easy.
Mr. Attorney, then?
Election. He's not there.
He's not here. These elections. One is conscious.
Yes, Mr.
With the global canvas on election funding, party funding, campaign funding is like a kaleidoscope. I mean, it presents very interesting items, experiments made, and just as a learned solicitor were talking about experimentation. And he has referred to one of the most oft-quoted judgments in US, the New York Ice Company versus Lehman Brothers. Experimentations in economics and related branches to stay experimentation. The court looked at it with a distaste. If you look at all these experiments and how they have either invited a wide range of concerns. So I would address your lordships on three or four important aspects of the constitutional issues raised in this case. Before I do that, a very broad brush has been stated in this case. It is said that the scheme violates Article 14, 19, 21, and also undermines the basic structure of the Constitution. I think we need to take stock of this kind of propositions very closely. Alongside, it also said, well, here is a manifest arbitrary, and therefore Article 14 is attracted. I suppose that we must pay very close attention to an argument because a constitution bench, in terms of Article 145, looks at substantial issues of interpretation of provisions of the Constitution. Except when a reference is made on a difference between different benches. So the substantial questions of interpretation of the Constitution, there has to be something very precise, direct, and not too overbroad statements, which may resemble a political debate. I understand that a good part of the arguments made come closer to a political debate rather than precise statement of infringement of any particular constitutional right. Why I say that is placing reliance on two judgments of your lordships in the Association of Democratic Reforms and the PCL case that for the purpose of expressing your choice of a candidate, and you need to know the criminal antecedents of a candidate, a specific issue on hand, and a concrete right to be exercised, the choice of a candidate. So when you have a right to know under that, you are not asking the court to declare that in Article 19(1)(g), the citizen should have a general right to have a knowledge about everything and anything in relation to the affairs of the community. You have a task on hand, namely the choice of a candidate. So therefore, you need to know something about a candidate. Therefore, it follows that you must have information relevant for informing you as to how you'll exercise your choice. Therefore, the information issue will always be related to the an expression with reference to a particular issue on hand. If you may put it like this, information relevant for determination of an issue, can be a freedom of expression. And that if there is a denial of that acquaintance, then we say there is an interference with the freedom of expression. So somebody calls it mutilation of the thinking process if the information is not available. So we talk about an issue on hand, and a denial of acquaintance of information forbids your ability to formulate an opinion and to reach a choice. So this scheme on hand is not concerned with political contributions per se. That's why I think the court would not get into the larger questions of where should political contributions come from? With what interest do they come from? And to what extent interest can be regulated? All those issues, I think, are completely alien to the scope of the inquiry in this case. That's why even if lots are invited to say the level playing field, it's only marginally relevant where one is looking at the effect of the scheme. Otherwise, those concerns, as I said, are completely alien to the narrow issue which is presented for consideration before your lordships. Because it happens in the generality of debates on election funding or political funding that one common starting point is that electoral reform is a claim that current systems somehow adulterates the outcomes that a purer system would produce. So we're not entering into the debate at all. Whether do we have a purer system and an adulterating system, how do you weigh them? Several imponderables would come into this question, both political, social, and economic. Therefore, that question not being relevant for consideration by the court. I'm just reminded, I'll read a very interesting statement made, not directly connected to this, but when the court is being asked to get into an arena of concerns, thoughts, and matters, and the court is asked to say, look, I step in and give something better. So that's these words by a famous economist, John Maynard Keynes, way back in 1933. I'll just give it to you after I finish reading this. Because when the community or even an individual is confronted with difficult choices, the question is in place of what prevails now, and if an alternative was to come in, it is not very clear about that alternative. I am perplexed. So he makes this very interesting statement. The decadent international, we are talking about capitalist power. Of course, capitalist power. But the capital today remains the lifeline of the nation. So he says this, the decadent international but individualistic capitalism, in the hands of which we found ourselves after the First World War, is not a success. It is not intelligent, it is not beautiful, it is not just, it is not virtuous, and it doesn't deliver the goods. In short, we dislike it, and we are beginning to despise it. But when you wonder what to put in its place, you are extremely perplexed. So these are very important words when any alternative system is sought to put in place. These questions have to be asked. So when we talk of the scheme being put to test and, let's say, undermining a basic structure doctrine as Mr. Prashant Bhushan has put in his written submission. I want to deal with some of those issues so that straying away from the question for consideration and to sometimes draw a very broad statement about basic structure can become problematic. It can become too doctrinaire also. So I suppose the court it need not be called upon to enter into those questions at all here. There's one very inviting thought process that comes to all of us is that we tend to say basic structure doctrine is undermined or is in a way in peril. We tend to lose track of the features of the Constitution which are consolidated in the basic structure. There could be an individual picture which can be undermined or in breach. So it is the architecture of the Constitution which is brought in and say basic structure undermined. We have to give very close attention to whether that can ever happen at all in the way it is stated. I wanted to share this broad statements and a few more propositions before I take your lordships through. Just digressing here for a minute. We talked yesterday about free and fair elections and the level playing field, even though I said they're not relevant at all. I asked myself a question: if the information which now becomes coded under the scheme, coded in more than one way, is to be disclosed, and all citizens have a right to access to this information. What is that end which I will put to use by way of accessing this information? General political debate, or determining which party will do better, or we will talk about the quid pro quo after the quid pro quo event has occurred. So therefore, I'm asking the question as to for what end and for what concrete purpose is access to information, the information, if disclosed, would become relevant.
Come back after lunch.